Well, from the letter that the Secretary to the President, Mr. Asante Bediatu, has written, there was an effort to transmit the bill to the office of the President, in fact, to the President. And so I can say that there was an effort to transmit it to the office of the President. But they are the ones who I believe have refused to receive it or accept it.
I'm asking this because your colleague just said there that the president ought to act as a constitution mandates within 7 days or face some legal action, which presupposes then that the bill currently is sitting at Jubilee House. I wanted to just be sure that that has happened. And now we are having this back and forth. What's the way out of it? The president, through the secretary, says he's restrained by multiple suits against this bill. He would want to see that the Supreme Court disposes of the suits before he can proceed on whether or not to sign it. He said he's been advised to act that way by his principal legal advisor, the Attorney General. Do you blame the president?
I will blame the president because the suit in the Supreme Court is seeking to restrain him from assenting to the bill. What he has done is to write to the Parliament saying the Parliament should not even attempt to transmit the bill. There is no interlocutory application before the Supreme Court seeking to restrain him from receiving a copy of the bill. There's no such application. So he should have received it. So for him to say that I will not receive it and Parliament should not attempt to transmit it because there is a suit in the Supreme Court is manifestly wrong. It betrays a man who already does not want to assent to the bill and is just looking for excuses and is making up obstacles in the way of the bill. That is what it betrays. Because the suit and the application that is before the court and the orders they are seeking are to restrain you from giving your assent to the bill. Then Parliament transmits the bill to you. Then you say, I will not take it. And don't even attempt to bring it to me because there is a suit in the Supreme Court. What is the suit about? It is to prevent you from assenting to the bill, not to receiving it from Parliament. So he has to receive it from Parliament. And then he has to now act on the advice of his Attorney General, which advice he might choose to communicate to us or to the rest of the country, but which advice he must make sure is consistent with the provisions of the Constitution. I'm a lawyer. I'm not going to advocate that anybody defies the Supreme Court because I'm in the Supreme Court seeking their orders in relation to other matters. If I didn't believe that they had the power to issue orders, I would not be there. So I'm not in a position to say, if you respect the Supreme Court, do not follow the orders of the Supreme Court. But what is actually before the Supreme Court? It is an application to restrain you from assenting to the bill. But what have you done? You have refused to accept a transmission of the bill by Parliament to yourself. And you are citing the application to restrain you from assenting to the bill as your reason. And I think that is clearly wrong.
So there's a view then that once the action has been commenced in the court, it automatically injuncts everybody and that the status quo ante must remain. Is that not what the president is ensuring happens by saying that do not even bring it to me so that we wait until the Supreme Court clears this matter?
He is not the one to tell Parliament that do not bring it to me. Parliament is the one to assess whether or not there is a suit in the Supreme Court that restrains it from transmitting the bill to the president for his assent. If they decide to defy the Supreme Court, it is Parliament that will suffer the legal consequence. The president does not suffer any legal consequence in just receiving a transmission of the bill by Parliament. He can receive it and he can still write to Parliament saying that I have received your bill and I see it is the bill in respect of which there is an application in the Supreme Court seeking to injunct me from giving my assent. And in view of the position of the law AYZ, I am going to act in this way or that other way. That is what the president should do. But to say to Parliament that don't even attempt to transmit this document to me, because I think it is a document in respect of which there is an application in the Supreme Court, the president is very wrong.
The injunction application, is that not to restrain the Speaker and the clerk to Parliament? And so what the President is simply doing is to draw the attention of the House in case House of Parliament may not have seen that injunction application, or remind him that you are stopped from going ahead?
The president is not the one to enforce the decisions of the Supreme Court.
But the president
in the manner in which he is seeking to do it.
But he can inform you and tell you that you are bad. Do not proceed.
I am saying that the president should receive the document. He can write to Parliament after he has received the document, and he can draw the attention of Parliament to the pendency of the suit if he thinks Parliament is unaware of the pendency of the suit. Strictly speaking, if they really know how to organize a presidency, what they will do is receive the document, acknowledge receipt of the document, draw attention to the matter, maybe even say that, he wants to seek the advice of the Attorney General in the matter or something of that sort. But I have a very strong reservation in relation to the decision not to even receive it and then to jump into, writing to Parliament and then telling Parliament, don't even attempt to transmit it, when the Constitution is clear that when the bill is passed, it ought to be transmitted to you, and then when it is transmitted to you within a certain day, you have to either sign or not sign. You could have taken it and done what the Constitution says, which is refer it to the Council of State, refer the application injunction to the Council of State, attach all the documents and say, look, I have received this. Council of State, can you advise me as to whether or not I should give my assent to this bill? Because that's what the Constitution says. Council of State can say, well, yeah, we've seen the legal issues in court and etc. Our advice to you is that you should not give your assent. Then he will write back to Parliament and say, well, I received it pursuant to the constitutional provisions. As the Constitution dictates, I have referred it to the Council of State because I don't think I want to sign it because there's a matter in court and the Council of State agrees with me on this matter, and so I'm sending it back to you. There are so many processes. Just follow the procedures laid out in the Constitution so that you are safe. As it is now, I don't believe that the steps the President has taken is consistent with the Constitution. He is not protected in any way. Parliament has passed the legislation, and Parliament has transmitted it to you. I haven't read the specific wording of the orders sought by the applicants in the court. I don't think that one of the orders they are seeking is to restrain Parliament from transmitting the bill to the President for his assent. Even if it is one of the applications they have made, it is for Parliament to suffer the consequences of defying the court. As for the President, when he receives the transmitted documents, he doesn't commit any offense, he doesn't violate any constitutional provision, he just received the document. Then he can act, according to the laid out processes that the Constitution sets out for dealing with bills that are presented to him for his assent. I think on this occasion, the President really, didn't do the right thing.
We are hearing that Parliament is trying to do a tit for tat by refusing to approve the President's minister nominees unless he goes ahead to take action on the bill. Has that information come to your attention?
No, no such information has come to my attention. But I know that the president has his nominees before Parliament. I know that the committee finished its work on it. I also know that one of the MPs, Honorable Roxanne Dafiamapo, went to court because he thinks that the president acted wrongly, because his own communication to Parliament indicated that he had, removed those appointees from their various positions. Then in another breath, he then writes to say that he is, reassigning them to a different ministry. And that language is wrong, because once you have removed the person from his post, he is no longer available as a minister to be reassigned. And so Dafiamapo is counter on that technical point to knock the president off.
So would you also as a House say that you would wait till the court decides on Dafiamapo's case before you proceed to approve them or otherwise?
Well, that's for the Speaker to decide, because Dafiamapo's action is not directed at me, and so it is for Speaker to decide, based on the facts before him, whether or not he's going to accede to Dafiamapo's application, and whether or not he also interprets our law the same way that the president has interpreted it, and said that once there is an interlocutory application, you must take your hands off. If the Speaker also decides that that is how he also sees the law, then of course he must also conduct himself the way that the president has conducted himself.
Very well. Thank you so much for speaking to us.
Thank you very much.
That's Mahama Ayariga. He's Member of Parliament, Bawku Central, speaking to us on the seeming standoff between the Jubilee House and Parliament House on the anti-LGBTQ